The following news flash is brought to you by the Lone Star Lowdown, providing your daily bulletins for the commodities market. Today in history, news updates, and the inside scoop into the tides of the alternative. Markets for Wednesday, the 22nd of June, 2016, are currently trading with gold at $1,265.56 an ounce, silver $17.28 an ounce, Texas crude $48.85 a barrel, and Bitcoin dropped to 625 U.S. currency. Today in history, last year, 2015, South Carolina Governor Nikki Haley calls for the removal of the Confederate flag from the State House grounds in the wake of the senseless killings in a Charleston historic church. It was this event which led to the nationwide ban on the Confederate Dixie flag. Today in history. And recent news. House Democrats had a sit-down on the floor of the House chamber today. They effectively forced the House into a temporary recess as part of an effort to get Republicans to vote on gun control legislation. Representative John Lewis, Democrat from Georgia, a civil rights leader who led sit-ins all throughout the 1960s, led the effort with sharp criticisms towards Congress for not voting in favor to pass more gun restrictions. Democrats are planning to essentially hijack the House floor both Wednesday and Thursday in an effort to get gun control measures a hearing. A spokeswoman for Representative Speaker of the House Paul Ryan, Ashley Strong, said that, quote, "The House cannot operate without members following the rules of the institution, so the House has recessed subject to the call of the chair. As the minority party, Democrats have virtually no power over which bills are voted on. The only thing they can do is protest or use procedural maneuvers, of which they plan to do both this week, so keep your eyes on the House floor." Ultimately, the goal is to force lawmakers to vote on a bipartisan bill that would give the FBI and Attorney General the power to ban people on the controversial no-fly list from purchasing firearms. According to a government report by the Treasury Department released today, the trust fund used to pay hospital insurance costs for Medicare will be emptied out by 2028, about 2 years earlier than calculated, while the Social Security Trust Fund has enough cash to pay full benefits for only another 18 years. The trustees overseeing both stated that reforms are needed in order to avoid cutting health care and retirement benefits for Americans. Acting Commissioner of the Social Security Administration, Carolyn Colvin, said that increasing payroll taxes by slightly more than 1% could improve the solvency of the fund over the next 75 years. Maybe it's time we start looking for and creating options that don't involve Uncle Sam. This is Rick Rohde with your lowdown for June 22nd, 2016.
You gonna do? Yeah. Bad boys, what you gonna do? What you gonna do when they come for you? Bad boys, what you gonna do? What you gonna do when they come for you? When you were 8 and you had bad traits, you go to school and learn the golden rule. So why are you acting like a bloody fool? If you get hot, then you must get cool. Bad boys, what you gonna do? Or what you gonna do when they come for you? Bad boys.
Okay, howdy, and welcome to that Really Love video on this Friday, the 24th day of June, 2016. Well, we had the hearings by the Senate Subcommittee for sunsetting the bar yesterday, and again, I were planning on going down and giving a presentation, and they were restricting us to 3 minutes, so we decided just to write up a presentation instead. Ken Magnuson, he wrote up a scathing indictment of the bar, explaining all of its failures and advising a number of changes to be made. Well, we've done all that in the past, and for the most part, these people are going to do whatever they're going to do, and they just ignore it. So I took a different approach this year. I started out my statement by saying, "Don't mess with the bar. As far as I'm concerned, the bar is perfect. Don't do anything to it." And those of you who listen to the show for any length of time, you understand why I'm saying that. I went on to explain how if anyone files a bar grievance against a lawyer with the State Bar of Texas, no matter what they complain about, valid, invalid, makes no difference, the State Bar will send back to them a notice saying, "We examined into your accusation and find it does not rise to the level of misconduct." It makes no difference what it is. And then they'll take your complaint and your grievance, and they will throw it in the trash. And that's a good thing. And the reason it's a good thing is their insurance carrier knows they'll throw it in the trash. So how is the insurance carrier to gauge its level of risk? By valid arguments, it's throw them all in the trash by the numbers. Just like if you buy a new car and take it down to Walmart and go and come back out and somebody's bashed in a fender. The insurance company's going to come out and fix it, and they're going to double the rates. You go back next month, somebody bashed in another fender. They're going to come out and fix it, cancel. Your fault, their fault, nobody's fault. They don't care. You are a bad risk. There are about 14 legal malpractice carriers in Texas. I've looked them all up. I've got an email list of them. So if anybody's going to file a bar grievance, let me know. I'll send you that email list, and you can CC it to all of these insurance carriers. But all of those carriers are all underwritten by Lloyd's of London. They all have the same standards. One bar grievance your first year of practice, they cancel your malpractice insurance immediately. 2 grievances any 1 year practice, they'll cancel. 3, they'll cancel your law firm's malpractice insurance. And I'm telling the bar, since the State Bar Association, as it is absolutely worthless as an oversight agency for Texas lawyers, they create a situation where I can take incredible unfair advantage of lawyers. And I explain to people, if you get a lawyer, you need to understand that lawyers are in business. These guys aren't Perry Mason. They're not here to protect the weak and defend the downtrodden. They're in business to make money. It's all about making money. When you go to a lawyer, they give you this song and dance and sell down your pants. They tell you all this stuff. They're going to do what a great case you have. Now we can whip them big time. All that lawyer's trying to do is get your retainer. Once he's got your retainer, he's got this set of motions and responses that he because he knows the lawyer on the other side has the same set of motions. So they do this flurry of motions back and forth. One lawyer reaches in his drawer, pulls out the standard motion, and files it. The other lawyer gets it, he reaches in his drawer, pulls out his standard answer, puts his client's name on it, and files it back. And they fire these things back and forth until they use up your retainer. You see, the charge is if they write out each one of these motions just for your case. They never tell you they already got them written out. So they use this to use a retainer. Once they've used up your retainer, they don't want to mess with you anymore. They do not want to go into court and actively adjudicate your issues. They're afraid to. When a lawyer goes into court before these arrogant, self-serving, self-righteous judges, he does so dangling by his bar card. A judge can jerk his bar card on a whim. And these lawyers are afraid they'll do just exactly that. Now, maybe these judges aren't self-serving, self-righteous, no good scoundrels. But lawyers believe they are. Lawyers know that a judge can sanction them at their caprice just because they don't like the way the lawyer parts his hair. A judge can pretty well do anything he wants to do to a lawyer. So you and I, as private persons having to hire lawyers, we need to understand how to deal with them. And I'm all in this stand. I explain to people how it's not about law. You'll never win your case simply because you have the law and facts on your side. You win your case if you have the politics on your side. And all politics is local. And for the most part, it all centers around the money. So when you go and sit down in the courtroom, it's like you're sitting at a four-sided chessboard. You're sitting at a table. To your right is your lawyer. To your left is opposing counsel. Across from you is the judge. You have a relation with your lawyer. Your lawyer has a relationship with opposing counsel and with the judge. And they both have a relationship with your lawyer. You're the odd man out. If you're going to win your case, you need to invoke a little politics. And the best politics you can invoke goes to plausible deniability. You want to give your lawyer plausible deniability. So he can go to opposing counsel and judge and say, guys, no, we all know each other. We all work together. You got to help me out here. I got myself an unruly client. You guys got to help me out with this unruly client, and I'll pay you back on the next client. We'll screw him real good to your benefit. You just got to help me on this one. The way you do that, it's your bar group. You don't negotiate with him. You don't warn him. If he doesn't do what you believe he should do, grieve him. Oh, he's going to get real excited. But if he says one thing to you, one word to you about the bar grievance, you bar grieve him for that. Now he's going to go to the lawyers on the other side and say, I've got a client here who's busting my chops. You got to do something to help me get him out of here. And the last case I had, they dismissed the case to protect my lawyer for me. I'd already told the lawyer that, he's telling me how things are going to go because they appointed this lawyer for me. I didn't ask them. They just decided I needed one and appointed me a lawyer. And he's telling me how things are going. And I said, no, that's not how they're going to go. Well, how are they going to go, Mr. Kelton? This is how they're going to go. You're going to go to the judge and ask the judge to remove you from this case. And I'm going to go to the judge and tell the judge, don't you dare remove him from this case. He's my lawyer of choice, and he's under contract. And the lawyer said, well, Mr. Kelton, I'm not under contract with you. I'm under contract with the state because he was court appointed. I said, yes, you are. But I am the third-party beneficiary, and I have standing before the contract. And the judge is going to remove you from the case. And he said, yes, you will. Then I get to sue the judge for interfering with the private contract. And the lawyer sat back in his chair and looked at me, and you could see it in his eyes. He's going to get me disbarred. That lawyer told me that if he said it once, he said it at least 20 times, that I was going to get him disbarred. I want a Frank's hearing. Frank's hearing is a hearing for the purpose to determine the veracity of a police officer who testified for a magistrate to secure a warrant. We can't do that. You'll have to subpoena a judge. I said, yeah, I know. Well, I can't examine a judge on the stand. I'll get disbarred. Don't worry about it. I'll examine him. He hadn't lived until I worked him over. Oh, Mr. Kelton, you're going to get me disbarred. We went out to lunch. They dismissed the case to protect my lawyer from me. If you're going to win your case, you have to understand the politics. And this is what I explained to the legislators. And so because we have the ability to file bar grievances, and because the bar throws them out, the insurance carriers can't gauge their level of risk by valid bar grievances, so they just do it by the numbers. So if I bar grieve that lawyer because he's claiming that the shyster parts his hair on the left, it doesn't make any difference. If I charged him with stealing an old lady's entire estate and throwing her out on the street and causing her to have a stroke, I'm going to get a letter back saying, we examined into your accusation, find it does not rise to the level of misconduct. So I can bar grieve it for anything. And when I do, it's going to double the malpractice insurance at least. And it generally starts at $25,000 a year. I'm going to cost these lawyers a fortune. I'm likely to put some of them out of business. You see, guys, I don't need you to police the legal profession. We can do that ourselves. So I asked the Sunset Commission, just leave the bar alone. It's perfect like it is. We can have great fun with it and use your failure or the bar's failure to our own advantage. Now, I do have the phones open. We'll keep the phone lines open all night. If you have a question or a comment, give us a call, 512-646-1984. We're pretty well open to any subjects. So give us a call. And also, during the breaks, you might have a look at our sponsors. We're struggling to keep this show on the air. The host, none of the hosts paid for doing these shows, and for the most part, we pay out of our pocket to keep this thing going. And sometimes it gets kind of difficult. We do need to upgrade some of our equipment. So during the break, you might go to logosradionetwork.com and have a look at some of our sponsors. Have a look at that blue banner for Mike Beerus. He'll show you how to get credit card companies to pay you to go away and leave them alone. We've got Jurisdictionary. We've got a whole bunch of sponsors. You may need some of their products. They can help keep the show on the air. Hang on.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
It's out of control, on the edge of a hole, inside a deep dark bowl.
Okay, we are back. Randy Kelton, That Pack, Real Bar Late Radio. We're having a little trouble getting Vet on tonight. We seem to be having some technical difficulties, but we'll bring her up as soon as we can. I'm going to go to Joe in Texas. Joe, what do you have for us today?
Randy, I have a. Can you hear me good?
I can hear you. Move. Are you on a headset?
No, I'm just talking to my cell phone.
Okay, try to move it a little away from your mouth. I'm getting some really serious distortion.
Can you hear me now?
That's better. Yes.
I have a situation where I was incarcerated for 1 week at the county, and when I was released, it so happens that somebody was trying to use my credit card there at the county.
Wow.
And I went to the county and talked to a detective, and my credit card is trying to find, the fraudulent where it came from. And so I was going to ask you, how would I go about, do I file a criminal complaint against the county?
No, go to the Texas Rangers.
The Texas Rangers?
Yes.
Okay.
Ron Earl, he was the district attorney for Travis County, talked the legislators into funding a public integrity unit for the district attorney's office. And then Ron Earl used that public integrity unit to crucify his political enemies. And a couple other prosecutors did the same thing. So the last legislature removed the public integrity unit from the district attorney and gave that to the Texas Rangers.
Okay.
So now the Texas Rangers are charged with investigating complaints against public officials. And since you were incarcerated, they took your information, and the jail committed identity theft. You need the Rangers to look at this and see if this is a common experience or a common happening.
Okay. And what can I do as far as a recourse?
Okay, you're 512 area, so just find the local Texas Ranger. You're there at near the seat of government. It should get interesting.
Uh-huh.
And what I suggest you do is were you arrested by a municipality or?
No, the SWAT team, county SWAT team, I guess.
Okay, so it's a county. And since you're 512, I'm going to assume it's Travis or one that's close by. Okay.
Yes.
File criminal charges against the sheriff for identity theft.
Okay.
And file it with Texas Rangers. Make up a verified criminal affidavit. And you can look on jurisimprudence.com. I've got a bunch of criminal complaints on there that you can look at to see how to write them up. They're relatively simple. There are a few technical requirements. All complaints must run in the name of the state of Texas. And you must state that you have reason to believe and do believe, based on the following, that certain person committed a certain crime. And I have some forms. I have a bunch of complaints that I've written, and they're all in exactly the same form. And if you go to jurisimprudence.com and Top Frog on the right will take you to documents and research. And in there, you'll find a blanks folder. Just go down the blanks folder to complaint form, and you can pop a fill in the blanks complaint form.
Mm-hmm.
You fill out that form, and you sign it before a notary and have a notary verify it. You take that to the Texas Ranger. Now, they're not going to like that one little bit. What they want you to do is give them a voluntary statement. They don't want you to write out a verified criminal affidavit, because a verified criminal affidavit very specifically invokes their duty. They want to decide whether or not to file a complaint. Well, they're the servant, you're the master, and you don't care what they want. This in Wise County. And the Texas Ranger took my complaint. I sent it to him registered mail, so he didn't have any choice. And that's what I suggest you do. You send it to him registered mail, return receipt, so you can prove he got it. Once he has the verified criminal affidavit, he's been given notice that a crime has been committed and he's been given that notice by his master. Now, he has the duty to present the complaint to some magistrate under 14.03 Texas Code of Criminal Procedure. Well, when they set up the protocols for Texas Rangers, they added an odd requirement. Prior to this time, a Texas Ranger could investigate a public official, but only upon written permission of the director of the Department of Public Safety himself. So the legislature granted the Rangers authority to investigate public officials. So the director had no more say one way or another.
Okay.
So the legislature required them to set up protocols. And what their protocol called for is now they had to go to the prosecuting attorney and ask him for permission. Problem. Under Article 2.03, Texas Code of Criminal Procedure, a prosecuting attorney is forbidden to make a decision concerning prosecution of a public official. Absolutely forbidden. So I gave this complaint to the Ranger, sent it to the prosecuting attorney. I charged him with conspiracy to commit obstruction of justice. Conspiracy to induce the prosecuting attorney to violate Article 2.03 Code of Criminal Procedure. And I filed that with the grand jury. And now that Ranger is waiting to see if he gets indicted for following policy. And the reason I told you all that, if you do that in Travis County, then these Rangers who are following this deliberately contrived procedure are now getting people filing criminal charges against them. They're going to get really, really unhappy. And they're going to be unhappy at their boss. And what we want is the Ranger put in a position to where he doesn't have to ask anybody if he can investigate a public official. See, the director had political control. And when he lost it by legislation, he tried to get it back by shifting it to the prosecuting attorney and tried to circumvent the intent of the legislation. This is a sensitive area right now. So I suggest if you file criminal charges against the sheriff, you understand why I want you to file against the sheriff himself?
No.
Because all of those employees of the sheriff's department works for the sheriff. They act at his direction. And under law, he is respondeat superior. What they do in his name. So you get to sting the sheriff as if he did it himself. Okay. Now, if the sheriff doesn't want to wind up under the bus, he's going to have to find somebody else to throw under there in his place. And then when the ranger doesn't want to go after the sheriff, you go after the ranger. You know, I keep saying on this show, you never win your case simply because you have the law and the facts on your side. You win your case, you get politics. Okay, hang on. We'll be right back. Randy Kelton, Vet Pack, Root of Law Radio. Our call number 512-646-1984. We'll call.
Here in the U.S., a man's home used to be his castle. You'd need permission to enter or a compelling reason to break in, like a search warrant. I'm Dr. Catherine Albrecht, and I'll be back in just a moment to tell you how things have changed.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This public service announcement is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Police are irresistible, according to the Indiana Supreme Court. It recently ruled that citizens in that state cannot resist police entry to their homes, even when the entry is illegal. The decision stems from a case where a man was stun-gunned and arrested after trying to bar the police from his apartment. Justice Stephen David explained the majority decision, claiming citizen resistance is against public policy and is incompatible with modern Fourth Amendment jurisprudence. The Fourth Amendment to the U.S. Constitution guarantees citizens the right to be free from unreasonable searches and seizures. Seems to me it's the Indiana Supreme Court that's incompatible with the Fourth Amendment. I'm Dr. Catherine Albrecht. More news and information at CatherineAlbrecht.com.
You're listening to the Logos Radio Network at LogosRadioNetwork.com. Yeah, I got a warrant. And I'm going to serve them to the head government, them. Prosecute them. Okay. How's that? Citizens arrest for Mr. Bush. Citizens arrest for Dick Cheney. Well, I need a prosecutor to come and help me. Prosecute them wicked leader, you see.
Okay, we are back. Randy Kelton back with Law Radio, and we're talking to Joe in Texas. Okay, Joe. This is really serious business. I've heard of this. I have another guy that this happened to. That they gave his property to somebody else. And the guy took his credit cards and stuff and went out and started buying stuff with it. So this one doesn't sound that way. When you got out of jail, did you get your property back?
Yes, I had my property back, and then I tried to use my credit card, and then they had to cancel it because they told me somebody was starting to do fraudulent on it. And that was when I was in jail.
So have you filed a complaint with anyone yet?
Okay, this is what I did. I went, I think Thursday to the Travis County, and I talked to the detective. He just gave me a case number, and he told me when the credit card would investigate the fraudulent who was doing it, then to come talk to him. Well,
and there's an issue here because since this occurred while you were in custody, now you have reason to believe that this was done by the Sheriff's Department. So it's inappropriate to have the Sheriff's Department investigating the Sheriff's Department. So I suggest you make up a complaint of identity theft, take it to the Texas Rangers, and get a third party. So when you take it to the Texas Ranger and he's to sweep it under the rug and you land on him like a ton of bricks, he's going to be a real unhappy camper. And one thing I can tell you, every policing agency in the state of Texas, or all public officials in Texas, they're afraid of the Rangers.
All right.
The Rangers, if we have one truly professional policing agency, it's the Texas Rangers. When I mention Texas Rangers, everybody sucks wind. So if you sick the Texas Rangers on him, and then when the Texas Ranger, he wants to keep the peace, and he has to work with these people. When he tries to make this go away, and you slam him big time, he's going to go to these people and say, you guys got to get this fixed because I'm not going to lose my career to cover you guys. It's all about the politics. Does that sound like something you feel like you would be up to doing?
Definitely, for sure.
Okay. The case against you, how much is your liberty at risk?
I'm already free.
Oh, okay. Because I'm always concerned about asking someone to do something that will jeopardize his liberty. If they have a case against you and they're prosecuting you, this could affect how they deal with the prosecution. They may want to ramp up the prosecution in order to keep you from going after them. But if your case is over and they don't have a shot at you, then you're kind of free to go after them. Always liberty first. So you can have a lot of fun with this. Joe, it's one thing when they come after you. But when you go after them, wow, that's a whole other animal. And I can tell you from experience, it's a whole lot more fun when you're the plaintiff.
Yeah. Well, I want to do that for the first time. So, I appreciate your information, Randy. Thanks.
Have you written a statement of facts?
I haven't.
Write it down. Problem with not doing that is each time you tell this story, it'll change. Because you go in your memory and you pull up facts, but you only tell me those facts that seem important in this context, and then you put it back. And what they found out in research is we don't go inside and read our memory. We go inside and pull the memory out. And then when we re-experience the memory, that puts it back. That's a subtle problem because if you pull a memory and you leave out some of the details because they're not relevant to this situation, you put it back without those details. And that's kind of why people's testimony is so skewed, because they told the story over and over and over and they lose some details. They did some research with rats on this, and they gave them a chemical that blocked their ability to store memories. It's a date rape drug. Mm-hmm. And what they found was when they exposed the rat to something it knew it was trained to do, when it had this chemical, the next time they exposed it to that same situation, it had no memory. So when it pulled the memory, it literally pulled it out, and this blocked it so it couldn't put it back. So I encourage everyone, write down what occurred immediately. Okay. Don't matter if you get all the details. Once you've written it down, then you go back and look at it, and that will cause what they call revivification. It will revive the memories in between, because you store your memories in more than one place, and you can, a good written statement is better than a recording. So write it down. That fixes it in time. You can tell it 100 times and you'll never lose it. Okay. That's my story, and I'm sticking to it.
All right. Thank you.
Okay. Thank you, Joe. Okay. Now we're going to go to Charles in Georgia. Hello, Charles.
How's it going today, Randy?
It's going good, except we don't have Vet on. We're having some issues with her systems here. Her Skype is not finding her sound card, but we're hoping to get her brought on here pretty soon. Okay. What do you have for us today?
Okay, Randy. I didn't call you about me this time. I called you about a friend of mine who had some problem with the MERS and foreclosures in the past. And he asked me to give you a call and see what you had to say about it. His situation was he the way he explained it to me was they foreclosed on him, and he refinanced on the note. And he went to go sue these people because of the MERS, and he sent a letter to them stating, "Can you please produce the note?" And they wrote him a letter back saying that's beyond the scope of, what they can do or whatever. Basically, they don't have the note. And he went and filed a lawsuit. And he filed a lawsuit in the Superior Court of the State Court in a county here in Georgia. And what the bankers did was they had the case removed, and they removed it to the federal court. Well, as soon as they got the case removed to the federal court, no more than 4 days, they filed a 12B6 motion to dismiss failure to state a claim. And and my friend, he filed an answer to that 12B6. And
did he file a motion to remand?
No, he didn't.
Okay.
Well, but the judge granted the 12B6 motion to dismiss with prejudice. So I told him, I said, I know a guy. His name is Randy, over in Austin, over in Dallas, and he might be able to have something to say about that. And he told me to give you a call and let him know what the situation was. I'm curious to see what you have to say about it.
Okay, hang on. If you have access to the guy, you might want to get him, because I'm going to have some questions. We're about to go to break. Randy Kelton, Vet Pack, Root of Law Radio. We'll be right back.
Easy.
Okay, we are back. Randy Kelton, Root of Law Radio. Randy Kelton, Vet Pack, Root of Law Radio. We're still trying to get Vet back up. And we're talking to George in Charles. We're talking to Charles in Georgia. I'll get that right in a minute. Let's see. You didn't unmute. There we go. Okay. I got you unmuted finally.
All right. That works.
Okay. There are questions I will have. it's a standard procedure to remove to the federal court, no matter what. So I've been writing my complaints very carefully so that they only have state claims. Do you know what he claimed in his suit?
He claimed fraud against the bank because they had a note. Oh, I'm sorry, they didn't have a note. Couldn't produce a note. And when they asked him to produce a note, they came up with this letter writing them back saying that was beyond the scope of what they, of whatever they were doing.
Okay. The problem was claiming fraud. That always gets you into really murky waters in the federal court. So what I'm going to suggest, that they've already foreclosed. I would take it that means there is a trustee's deed filed in the public record. Okay. Do you know that there is that? That's why we need this guy, so I can ask him some specific questions. If they have already foreclosed, there's almost certainly a trustee's deed filed in the record. Now, first, what he needs to do is pull all of the documents that were filed in the county record from the time he received a warranty deed to date, and then look at those. If MERS is involved in the mix, they screwed everything up. Look at all the assignments. In Texas, we have a statute that every other state I've seen has this same statute in one permutation or another. And in Texas, it's Texas Property Code 13.001. And what it says is that any claim against real property not properly acknowledged or proven and filed in the public record is void as to the holder. And that's because say I'm going to sell you some property. You want to know that there are no hidden liens on that property. So if someone has a lien against my property, in order to be able to enforce that lien, they must file it with the county recorder. Now, at the turn of the millennium, the year 2000, the banks got 2 laws repealed that restricted them from running an investment scheme that they had designed. In 1995, they created MERS. When they created MERS, what they created MERS for was illegal. They couldn't do what they wanted MERS to do. They had to repeal the Glass-Steagall Act and the prohibition against derivatives trading. The prohibition against derivatives trading was put in 1907 to prevent people from betting on stocks without actually buying the stock. It caused a stock market crash in 2007, so they made it a felony to do that. And the stock market crash of 29 occurred because the banks were were speculating with depositors' funds, and they lost all the depositors' funds and caused the 1929 crash. So they put in the Glass-Steagall Act that forbade the banks from speculating with investor funds. Well, in 1999, they repealed the Glass-Steagall Act, and the last thing the legislature did in the year before closing sine die in the year 2000 was they repealed this prohibition against derivatives trading. This opened the door so that a lender could secure an obligation on a note. And then he could take that note and group it together with a whole bunch more notes into a pool and then sell this pool to an investor. And we had a lot of retirement funds that were looking for long-term investments. So we've got 30-year notes here, and we've got a retirement fund that wants to keep the retirement money in there 20 to 30 years. So it looked like a perfect marriage. Problem. Real property had lien reporting requirements that made it impossible for them to do what they wanted to do. What they want to do is put together this one investment pool and then sell a tranche or a slice off that, a percentage to an investor. So they sell these percentages to all these different investors. And then the investors could trade these percentages back and forth. Say they got 3 pools going here. One pool's making money, one pool's not making money. The pool that's making money, they're going to have to pay taxes on. So they take a tranche off of that pool and move it over to this one that's not making money. And this way they control their tax burden. Well, when they take a tranche off one of those pools, According to the reporting requirements, they're required to report, according to the Real Estate Settlement Procedures Act, they're required to report that change in beneficial interest in the county record. But when you got 10,000 notes and you slice a percentage off of it, then you have to go pay $50 a pop to file those with the county record. It would make it prohibitive. So they had to get a way around this. So they put MERS in place. MERS is standing as the straw holder. MERS is standing as if I'm the holder of the note, and then behind them, these guys are trading these notes back and forth. Well, it wasn't legal. It just wasn't legal. They could not find a way to make it legal. So now they have a problem. They really don't have a problem finding the note. They know exactly where it is. It's Ginnie Mae. Well, Ginnie Mae is the one that backs the pools. And what Ginnie Mae says is when a note's put into a pool, the note and all documents concerning the note are to be given to the custodian of the records. The custodian is almost always the servicer. So he's required to have the note. They got it. They don't want to produce it because if you look at it, the note is not going to have on there who actually holds it. And that's because there's 10,000 people holding it. And the people who actually hold it are changing around all the time. So producing that note can be really problematic for them, so they try not to produce it. And that's what brought up all this show me the note thing. But the courts have pretty well been bought and paid for. And they've really struck down this show me the note claim. So we look for a secondary way to handle this. And the secondary way I'd like to use is a quiet title action. Quiet title goes to strictly to state law. Real property filing requirements is a state issue. The feds have nothing to do with that. So you take this deed of trust and you say that the trustee lacked legal standing to execute the sale. Therefore, the deed of trust is fraudulent in terms of the state filing requirements. This is strictly a state issue, and you sue the trustee. Don't sue the borrower. The trustee is the one that filed the deed of trust, so you sue him. He will always be a state actor. So you've made a state claim. You've sued a party that is in the state. There is no way to get this to the Fed. But they'll remove it to the Fed anyway. Because if you look on the federal court website and look up 28 U.S.C., I think it's 1331. I'm sorry, 1441. They don't have new law. They don't have the new law reflected in there. In 2011, the legislature passed law that passed statutes that changed 200 years of law. It used to be that a federal court could take a case removed to it that had state and federal issues and hear both under judicial economy. Well, some of the circuits said, now, wait a minute. We can't hear state issues. That's an unreasonable preemption of state law. So there was a split between the circuits, and that's normally what the Supreme will pick up. So the Supreme picked it up. I'm sorry, the Supreme didn't pick this up. The legislature actually picked this one up. The legislature looked at it, and they passed law to eliminate this split. They said that while you can remove a state case with federal issues to the federal court, the federal court cannot hear the state issues. They must sever and remand. You see where I'm going, Charles?
Yep.
I'm not going to can you hear this, can't you hear this? I'm going to subject matter jurisdiction, and that's a big deal. And I'll explain that in a little more detail when we get back on the other side. Randy Kelton, Vet Stevens, Root of Law Radio. We'll be right back.
It's all according to the will of the Almighty. I read his book and it says he cares not for the unsightly.
Okay, we are back. Randy Kelton, Vet Stevens, Rule Our Radio, and we're talking to Charles in Georgia. If you carefully craft your suit to only go after quiet title, claiming that a document filed in the public record doesn't meet the state filing requirements, you only ask for declaratory judgment. That way you're not asking for any damages. You just want this document ruled void. So they're going to remove it to the Fed. They remove everything to the Fed. And when they do, in the Fed, you file a challenge to subject matter jurisdiction. Now, the Fed is expecting a motion to remand, but you don't give him a motion to remand. You give him a subject matter jurisdiction challenge because under the Venue and Removal Clarification Act of 2011, the judge has no subject matter jurisdiction over a state claim. That's a big deal. Because now you put the judge on the dime. I had Judge McBride. He is a real scoundrel here in Fort Worth. All the lawyers hate to go before him because he's so arbitrary and capricious. They're all terrified of him. He'll sanction them at the drop of a hat. I filed a quiet title. They removed it. I filed a challenge subject matter jurisdiction. They filed a Rule 12. And in their Rule 12, they claimed that the pleading should be dismissed because they were not the creditor. And I saw that. That said, say what? They're trying to foreclose, but they state in a pleading in the federal court that they are not the creditor. Holy mackerel. So what do you do when you get something like that? You know the lawyer's made an error. So you non-suit right away so he can't correct his error. And the state becomes collateral estoppel. So I non-suited immediately. The same day I non-suited, Judge McBride dismissed the case with prejudice. Under the Rule 12, he jumped over the subject matter jurisdiction. Bad move, Bubba. Once subject matter jurisdiction is challenged, subject matter jurisdiction is lost. This is very fundamental law. When a case is filed, there is a presumption of jurisdiction. When the case was removed to the federal court, it came with a presumption of jurisdiction. And if nobody challenges it, then they act as if there is jurisdiction. But if the judge has knowledge that he doesn't have jurisdiction, he is required on his own to so rule. But if he doesn't, when someone challenges jurisdiction, that presumption of jurisdiction is lost. Now the judge no longer has jurisdiction. There is no jurisdiction until the judge proves it, not the plaintiff or not the removing party. It is the judge that must prove jurisdiction. If he doesn't, and he doesn't have it, that's the only time you can sue a judge. So far I filed criminal charges against McBride, official oppression, but when I'm done with that, I'll come back and file a suit against him. That's going to make him really, really unhappy at the guy who removed it to his court.
Yep.
And the thing about subject matter jurisdiction, it can be challenged no matter how remote in history. So, my suggestion to your guy, look at the court record. Look at the chain of assignments. Was there an assignment by a dead guy? This happens all the time. The lenders put together these mortgage companies that would write these predatory loans that were very profitable and then sell them to the bank at a loss. So that the mortgage company, although it's writing a lot of these profitable loans, they're selling them to the bank at a loss so that the mortgage company winds up going bankrupt and they bankrupt out all the profit. So the bank gets these highly profitable loans with no tax burden. And because of that, you find these mortgage companies during the height of the real estate bubble going out of business left and right. Well, that made them a lot of money, but it created them a problem. Because before they went out of business, they had to transfer their claim in the mortgage to another party. But the banks weren't doing that. So you look for an assignment by an entity that doesn't exist anymore. I find it all the time. If an entity ceases to exist and it holds a claim against your property and it doesn't transfer that claim, it abandons it. So they're trying to fix it by having MERS claim to act on the behest of this company. Well, how does MERS act for a dead guy? How does a dead guy hire MERS as an agent and then direct the agent in how to liquidate the dead guy's property? Good luck. Okay. That's the kind of thing you look for. You look for where Bank of America has assigned the property to some other company. And then 2 years later, Bank of America assigns the property to somebody else. And wait a minute. You can't assign it anymore because you don't have it. And I find this all the time. So just look at who assigned what to whom and when. And if you can find, this is not hard. I mean, it's really straightforward. If you can find places where the pieces don't fit together, it is in the public record. So the trustee knows about it. Whether he actually knows or not doesn't matter. He has imputed knowledge of what's in the public record. So if he claims authority to foreclose and a public record shows he doesn't have it, then you move to strike the deed of trust. And when they remove it to the federal court, you hit the judge with the challenge subject matter jurisdiction. And then it starts to get interesting. If you can get pushed back to the state, now they got a problem. Because the state has an interest in having their real property records to be accurate, and MERS has made a horrible mess of those. Okay, Charles, does that make sense?
It makes sense to me, everything that you just said, but the problem is this is not my problem. This is my friend's problem. Or I'm not going to say a problem. This is my friend's issue. And I think I'm going to have him give you a call tonight about that. It makes plenty of sense to me.
Okay, get him to call pretty soon. I've got a full board.
Okay.
If not, have him send me an email.
Okay, I will do that. Real quick, I'm not going to take up much time. Just to catch everybody up to speed, I'm filing a 42 against a city here in Georgia. And I came on a couple of weeks ago to ask you a question about why is it that I need to give notice to this city within 6 months of the time of the incident in order to sue them in federal court. Well, just a quick update. I sent the notice on the day, on the 6th month, by certified mail to the city, a notice of, I forgot the name of the Latin phrase that they use, but whatever that phrase is, basically I sent the notice to them, letting them know that I will be suing them in the courts. Now that that's done, I have not had my arraignment yet for this issue. And you
wait a minute, arraignment?
I have not put in it. I have not entered a plea yet.
Oh, okay.
But I did file a motion to dismiss because I missed that court date, and they took me directly to jail for that. When I showed up over there and let them know, saying I missed my court date, well, they took me to jail for that, for missing the court date. So on that date, I had filed a motion to dismiss on that day, and basically explaining, hey, that we're going to have a lawsuit on your hands in the motion to dismiss. Now I need to ask a quick question. Since I really don't even want to deal with the municipal court at all, can I just file my 42 and file an injunction and just have this thing in the federal court?
Okay. Hold on. They arrested you for failure to appear, I take it?
For failure to appear on a Thursday. I showed up on that Monday, and they arrested me for a failure to appear.
Okay, so they're going to find letter of law. You need to take them to find letter of law and give them a subject matter jurisdiction challenge. Have you read the transportation code for the state of Georgia?
I've read the part that pertains to me.
The right to travel?
There's nothing about the right to travel in the transportation code.
Does the transportation code indicate that it is for the purpose of regulating commercial traffic?
That is.
How did they bring you within the statutory scheme?
Well,
this is a municipality. Municipalities cannot write law. They can only write ordinances. And those ordinances only apply to the corporation, employees of the corporation, or someone in contractual privity with the municipality who has agreed to the statutory scheme. How did you agree to this statutory scheme?
Well, I never did because I'm not a resident. I don't have a license in Georgia. I have a license in Michigan. So I'm not.
Okay, this is the one where they. Okay, hang on. We're about to go to break. We're going to run out of time here. Randy Kelton, Vet Pack, Real Law Radio. We'll be right back.
This is the Logos Radio Network.
Ain't gonna blind me. Don't bore me.
Okay, we are back. Randy Kelton, Vet Pack, Real Law Radio, and we're talking to Charles in Georgia. There were a couple places I wanted to go to. Here, the judge claimed that you failed to appear at the date and time that he demanded that you appear. And he ordered your arrest. So where did a municipal judge get authority to have you arrested?
Well, that's a good question.
Because he only has jurisdiction over crimes that are punishable by fine only. He would have had to take that failure to appear charge to a county court and have the county court issue the warrant. He can't.
You know, I brought that up to a former judge here, and I don't think the rules are the same here as it may be in Texas when it comes to that particular issue.
Now, hold on. Rules. We don't care about rules. We care about statute. The courts make up the rules. The legislature writes the statute. Where did the legislature give a municipal judge authority to enforce a crime, to make a claim against a citizen that carried a term of imprisonment? They don't get to just do it because it's convenient. And the fact that they have been doing something a long time may give the appearance of law, but it never gives the authority of law. So you need to ask that judge to show you exactly where he has authority to have you arrested. Now, this is not contempt of court. He can have you incarcerated for contempt of court. This is a criminal accusation of failure to appear. To look it up in Georgia law, it's going to be a Class B misdemeanor.
Okay.
And then you go back and claim the judge acted without subject matter jurisdiction, and they're going to say, well, this is how we do it. And I don't care how you do it. I care what the law says.
Correct.
So that's one thing to go after them. The other one is, how do they get you under the statutory scheme? What does Georgia law say about who can enforce the traffic code?
You have to be certified by the GDOT, Georgia Department of Transportation, to enforce the transportation code.
Did you request the certification for this officer?
I have not. But
I got my last ticket thrown out because of that. I have a letter right here from the chief of police in Decatur, Texas. It says that he cannot respond to my open records request. He has no records responsive to my request because his officers do not enforce the Texas Transportation Code. They dismissed the case. I did a failure to appear. I didn't show up when not supposed to, or they dismiss the case anyway.
Okay.
So that's the next place to go. Put in a request for that certification. And have you looked at Georgia law to see who can be certified? Let me explain why this is a problem for them. When they look at this certification process, what they're thinking is these are DOT officers. These are the guys that stop commercial trucks. And the certification is teaching them how to inspect commercial trucks. It's not clicking to them that that's the only thing the code applies to. And this is what the chief of police's problem was. He assumed that you've got DOT officers and then you just got traffic cops. So no. There's only one set that enforces the traffic code, and that's the DOT officers. The rest of them don't have authority. That's the way it is in Texas, and I suspect it's the same way in Georgia. They've just been doing it, and nobody's really challenged it. And they make a lot of money doing it. So the courts are real reluctant to rule in your favor. But, it's all about money. You want to give them a reason to make your case go away. But in your case, you really want to give them opportunity to create more tort against you.
Yeah.
So you might, first thing to look at is that arrest. That shows that they're holding you to fine letter of law. So you have a right to hold them to the same letter.
Yeah. Okay, so that's what I'll be doing. I'm going to go back. When do you guys update your archives? Because I got to listen to this again. I'm not in a place to write this stuff down.
Okay, good. And sometimes when I go over these, I'm kind of pedantic. And that's because I'm trying to get all of the detail in there so that you can go through the archives and pull it back out, because I don't expect you to understand all this all at once. It took me several years.
Yeah.
So and I do apologize if I sometimes sound like I'm running on and on, but there are a certain set of key elements that need to be in place. And once you kind of got the sequence, then you can fill in the blanks pretty easy. But if you lose one of those key elements, you can wind up getting clobbered.
Yeah, I don't want that. I've already been clobbered, so I'm not trying to do that.
So now it's your turn to go back after them.
Yep.
Okay. Let us know how this goes, Charles.
Thank you, Randy. I appreciate it. And I'm going to be having my friend call you. You should be calling me tonight. He's trying to get in, but I guess the cardboard is full, so he'll be calling in shortly.
Okay. Thank you. Okay. Now we're going to go to Steve in Florida. Hello, Steve. What do you have for us today?
Hi, Randy. How are you? It's good to talk to you.
I'm good. I woke up this morning. I checked the obituaries, and I wasn't in there. So it's a good day.
That's real nice. I've spoken with Mr. Ed Craig in the past about an incident that happened a short time ago, where I was down on vacation visiting my mother, and the call came in. I was assaulted by police in vacation town, and I spent 4 days in jail. However, now I have local attorneys down there at the vacation town, and I want to understand what exactly are the rights that I waived if my attorney enters a plea on my behalf or on my wife's behalf. She has 2 resisting charges. I have 2 assaults on Leo's.
Okay. Details. What was the nature of the claims? Okay, wait, let me back up. You asked a specific question. As far as I know, when you enter a plea, you don't waive any rights.
Okay.
There's a lot of people that do a lot of patriot mythology, song and dance about that. But it's like they're just looking for a reason to argue. Entering a plea does not grant jurisdiction. It doesn't waive anything. So there are fights to have, but we don't want to have fights that we can't win, or that if we win the fight, don't make any difference.
That's right. I have an incredibly unconstitutional assault, violation, kidnapping, imprisonment, I can't accept that, and I have to confront this, and I'd like to make it stick. I believe all charges should be dropped. That's the way myself and my wife are approaching this. And our attorneys, I feel all politics is local, and they might be.
Okay, you got to realize your attorney's going to throw you under the bus.
Yes, sir.
That's what they do.
Mm-hmm.
Unless you give your attorney plausible deniability.
Seafood lovers, beware. A new undercover investigation has found that half of Massachusetts seafood is misleadingly labeled as a more expensive variety. I'm Dr. Catherine Albrecht, and I'll be back with details on this fishy business.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This public service announcement is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
New Englanders will tell you fresh cod is a delicacy worth paying for. Problem is, your chances of actually getting the cod you order is no better than 50-50 these days. According to an investigation by the Boston Globe, nearly half of all seafood sold in Massachusetts is wrongly labeled as a more expensive variety. The riskiest order was tuna. Every sample tested was, in fact, a cheaper variety. In most cases, escolar, which can cause stomach upset. Other common replacements include tilapia for red snapper, catfish masquerading as grouper, and farm-raised salmon labeled as wild. Sadly, seafood has become fishy business. I'm Dr. Catherine Albrecht. More news and information at CatherineAlbrecht.com.
Chemtrails.
Looking for some truth? You found it. LogosRadioNetwork.com.
Okay, we are back. Randy Kelton, Vet Pack, Roosevelt Radio, and we're talking to Steve in Florida. Okay, your issue is not traffic. Yours is assaulting officers.
Yes. Vacationing, looking at the lovely town, which is a tourist spot, and a call came in that said I was grabbing my wife, or she tried to walk away, and I walked behind her. So we were stopped 90 seconds later after the first dispatch, and the officer on a bicycle gave me 5 seconds or so to produce a license. Give me your license now. We stopped you because we had a call. Give me your license now. Grabbed me and started arresting me. And so the charges were dropped for the initial stop. There was one about not producing a license, like an obstruction charge, which was dropped. Mine was dropped. My attorneys advised that it was dropped. They told me on a call that it was dropped. I'm wondering, and also the initial stop would have been for domestic violence. That was also dropped. I was told by my attorneys last week. So I'm wondering about Fruit of the Poison Tree, what these assaults hang on, period.
Okay, wait a minute. So have all the charges been dropped?
Only the DV and the ID. The two assaults on officers had not been dropped.
What was the nature of the assault on the officers?
Well, that goes into, they said that I was fighting and grabbing them and not complying or going down to the ground, as they screamed down to the ground and tried to leg sweep me. So that would be the essence of it. There was no, they reported in the report that that I hit an officer with an open palm, and there were more details to that, but I never used any kicking or fighting motions. I was simply.
Did these guys have body cams?
No, sir, not. I've not been able to confirm that they have, and I believe I've spoken with people who would know, and they do not have there.
Yeah, the problem is, I take it you don't live in near where this occurred?
That's right. I was vacationing.
So they know they have you at an incredible disadvantage because you live so far away from where this is occurring. So all they're doing is squeezing you for money.
Okay.
Have you had your lawyer do any discovery?
Yes, as a matter of fact, they have told me and my wife that they are waiting on discovery, and have not been very forthright about what might be included or what specifically they have. They told us they have the one witness who's willing to say that the officers arresting us were quote-unquote dicks throughout the whole thing. I don't have details about what they have, the witnesses told them. I've been gingerly, in a way, polite in order to see if these attorneys will indeed work to drop off.
Okay. What the attorneys are going to do is they're going to huff and puff and threaten and make it sound like they're going to put you in prison for the rest of your life, and then they're going to offer you this great deal where you pay them a whole lot of money. That's all it's about. I don't know how to help you. This is a problem because if you live there and if you were close, you could fight this much more effectively. But if you're living a long way off, it's a problem. So what do you need from me? What can I do to give you assistance?
Can you tell me what a CITAPP?
Okay. Acronyms make me nuts. I have no idea what that means.
Okay, it's a hearing my wife has next Thursday. She and I believe that they are leading us towards entering a plea on her behalf of not guilty for the two resisting on-officer charges. And again, I do want to research if I'm waiving any rights regarding her.
No, you're not waiving any rights entering a not guilty plea.
Mm-hmm.
It waives no rights at all. If that's a concern, you can dispel that. Entering a plea does not grant a court jurisdiction that wouldn't otherwise have it. It doesn't grant it venue. It doesn't grant it anything.
Mm-hmm. Okay. I believe that when I become more pointed with the attorneys Monday morning, perhaps asking some questions via email and following up with them early Monday, I have an inclination that they're going to not appreciate the follow-up that I'm doing. And I know you suggest that we go pro se, but I just can't. I feel like when we go to hire another lawyer.
Oh, no, I don't suggest that you go pro se, especially when your liberty's at stake.
Yes, okay.
Get your liberty secured. If you want to go after them later, fine. But first, get your liberty secured. And they're not interested in putting you in jail. They're just interested in how much money they think they can collect from you.
Mm-hmm.
And how to handle this is too complex for me to say directly. I'd have to know a whole lot more about what went on. And it's really hard when you're at a distance. They have you at a great disadvantage, and they know it.
Mm-hmm.
Okay, is there anything else I can do to help?
Well, my wife and I are thinking that they just really don't have anything to hang their hat on, and that we would like for them to drop the charges. I'm wondering if a continuance should be filed on my wife's Thursday hearing, because mine, being felonious, is in fall. And if my charges were later dropped, or in the interim, if my charges were dropped, would that not naturally mean hers would be as well thrown out?
Not necessarily, because it depends on what the circumstances were.
Uh-huh.
If she slapped and kicked and gouged him in the eye, the circumstance is going to be different.
Mm-hmm.
So it all depends on the circumstances.
Well, as I mentioned, I did call Eddie Craig's show, and he replied to my email, so I'm so grateful, and I love your network. You guys have been an invaluable resource to me since my friend turned me on to you guys. And I learned a lot of stuff in the interim. I'm also wondering about the challenging subject matter jurisdiction. Is that something that I should even think about while I have these local attorneys who maybe...
No, it's a little more difficult in a criminal issue, because here they clearly do have subject matter jurisdiction. It's not like traffic, where the traffic only applies to commercial. Here, they've charged you with a crime under this statutory common law. And everybody is subject to the penal code. So you do fall within the statutory scheme. So we don't have that claim. In order for me to say what you might have, I'd have to have a statement of facts. Have you written one up?
Yes, I am working on it, especially as discovery comes my way. But I do have a red line of the police report showing how there's impossibilities, but what they say is factual.
Okay, well, you're being way too vague for me to be able to tell you anything specific. Hang on, we're about to go to break. Randy Kelton, Vet Pack, Roosevelt Radio. Our call-in number, 512-646-1984. We'll be right back.
Well, karma's lurking around the corner. You better watch every step you take. And good and good to follow you.
Okay, we are back. Randy Kelton, Vet Pack, Roosevelt Radio, and we're talking to Steve in Florida. Steve, I don't know what else I can do for you. I would have to have a statement of facts to kind of understand what all went on before I could give any kind of suggestion. It kind of worries me when I have someone whose liberty is at risk. You being so far away, being far away from where the prosecution is, makes it very difficult for you to really take them on. And from talking to you, you don't have a strong enough grasp of the code and how to implement it to be in a position to take on an issue where your liberty or your wife's liberty can be at risk. So I would be very careful here until I got the liberty issue handled. Okay?
Okay. Well, just in a nutshell, this is where the cops allegedly had reported domestic violence, and a lady on the street corner, while I had my arm around my wife's shoulder, my wife was looking at her phone and stepped down almost in oncoming traffic, and I said, "Sweetheart, the light's it's still red. The little walking man, white sign of the walking man is not on yet." So she stepped back up. The lady said, "Hey, is he bothering you? Are you trying to get away from him? Is he hurting you? Do you want to come with us? Do you want me to call 911? And my wife said, "No, he's my husband." And I said, "Frankly, ma'am, in all due respect, I think you're butting into our private business, and I don't appreciate that." I think that's what angered her, and she made the 911 call. We walked away around the corner, and the police...
Wait. I can't do this way. Can you write up just a timeline of everything that happened and then email that to me, and then call back and we can talk about it? Because going through the facts this way, it'll get really complex and we can spend the whole show trying to sort out all these details.
Sure thing.
But you absolutely need this written down.
You've given me a number of gems of advice that I've taken note of, so I thank you for your time and for taking my call.
Okay. Most important thing I can suggest is write down precisely what happened. A good written statement's better than a recording. And you can be sure these officers had mics on them, if not video.
Mm-hmm.
And request their recordings. When the cops screw up, they always erase the recordings. And that puts them in a difficult position when they don't produce their recordings. Okay, I need to move along. We've got a full board of callers.
All right, appreciate it, Randy. Good night.
Okay, good night, Steve. Now we're going to go to Oliver in Texas. Oliver in Tennessee.
Hello.
Hello, Oliver.
How you doing, Ron? I got a few issues. I wanted to kind of clear one thing up because I was reading the Tennessee Code of Statutes, and I found something up underneath it's called Civil Procedures, Title 2015, Chapter 15, Policy Granting Committee to Foreign Law, Legal Code, or System. And I don't want to read too much of it, but there's this one part right here that says application to foreseeable violations from foreign law, legal code, or system. It's like 20-15-1.
Wait a minute. You broke up there. I couldn't understand what you said there. Can you read that again?
It says application to foreseeable violations of constitutional rights from foreign law, legal code, or system.
Okay.
And then
I don't have enough referential index for that to make any sense. I don't know what the context of it is. Can you? They're referencing anticipated violations. That doesn't make sense. And anticipated violations of foreign law. What is the context of this statute?
This is the title is Civil Procedure. It's a policy, and the chapter is Policy of Granting Committee to Foreign Law, Legal Code, or System. I think committee is authority.
I don't know. It's a committee. Okay, what's the committee? What is their charter? What are what is the committee formed to do?
No, I looked up this committee, and this committee is mean like granting authority to. It's not an actual committee, a group of people. It's a system. I think this chapter is it's a public policy chapter about who is allowed to be regulated by foreign law, legal code, or system.
Oh, okay.
And I had the situation where they used the code, residential builder code, to demolish my house.
Okay, yeah, okay. Now I'm beginning to understand. For those who haven't heard all of it before, the city condemned his house. His house had a fire in it, and he didn't get it repaired quick enough because he's short on funds. And the city condemned the property and then razed it.
And took 12 vehicles from the property.
So you went in and looked at the law, and you found that they acted under a set of law to which you were not liable, that didn't apply to you.
Right.
So that's why you're talking about this committee about foreign law and what law applies. Am I in the right place now?
Yes, but the committee that is not the same committee that you're talking about. This committee is spelled COMITY. When I looked it up in the
committee.
Comity.
Okay. Let me look up comity. Comity has to do with standing. If, say, I'm a partner in a contract, I have comity toward that contract. Let me look that up. Control in COMITY. Now it's beginning to make sense.
Basically, these are the
comity, courtesy and consideration, behavior toward others, an association of nations or their natural benefit. I need comity legal. My computer doesn't spell very good. There we go.
It's basically authority to.
Okay. The term refers to the idea that courts should not act in a way that demeans the jurisdiction laws or jurisdictional decisions of another jurisdiction. A presumption that other jurisdictions will reciprocate the courtesy shown to them as a part of comity. This goes to full faith and I keep losing that last term. Okay. This is the idea it goes to. If you're coming before us, if you're in a jurisdiction and something occurs for which there isn't a law in this jurisdiction, you can go to another jurisdiction that has a law addressing this issue. And say you're in Tennessee and something occurs for which there is no law, but they got one in Kentucky that addresses this issue. What the courts and the legislators say is, we trust the legislature of other jurisdictions. We haven't addressed this issue, but they have. And since we haven't addressed it and they have, we trust that they have carefully addressed the issue and created good positive law. We trust their law, so you can bring their law into this jurisdiction. Full faith and credit.
I understand.
They give full faith and credit to other law. Does that sound like where you're going?
Right. No, it's like you're correct. I understand. That's the basis of it. But as you read on through the rest of it, you start seeing that it starts talking about a natural person and restrictions as far as would violate the rights of a natural person in this state guaranteed by the Tennessee Constitution or the United States Constitution or statutes or decision under constitutions, under those constitutions. So I'm thinking that, yes, that is correct. But in this wording, it's also stating that there are individuals, natural persons, who are protected from all these laws, all these foreign laws, legal codes, or systems.
Oh, okay. That makes sense.
Yeah,
I'm looking down through these definitions. Here's one that's a little better. Courtesy, respect, a disposition to perform some official act out of goodwill and tradition rather than obligation or law. The acceptance or adoption of decisions or laws by a court of another jurisdiction, either foreign or domestic, based on public policy rather than legal. I'm going to open it up, see what the rest of that is. Rather than legal mandate. And what I understand you're saying is, well, they can do that, but not if in doing that, in pulling that foreign jurisdiction law, not if it restricts you as a natural person in any one of your rights as guaranteed by Tennessee law.
Right, and it's clearly the United States and Constitution.
Yes.
Statutes, it clearly states everything in there. So I'm trying to figure out, it's a break coming.
Yes, there is a break coming. Hold on, we'll be right back.